On Tuesday this week, 5 justices of the Constitutional Court declined to nullify the Anti-Homosexuality Act of 2023 on grounds that the law was created to protect children and vulnerable people from the acts of homosexuality and to observe the norms, culture, values and religion of the country, among others. The decision has sparked mixed reactions from the public, including the West.
They expressed their displeasure to acts of homosexuality. They asserted their will and desires as provided for under Article 126 of the Constitution. You know, judicial power is derived from the people of Uganda, and the judiciary is meant to uphold and protect the desires, the norms, the will of the people, not the will of the foreigners, not the will of European Union, not the will of United States of America. It is time for Uganda to be let alone to manage or mismanage its affairs. The legislature is composed of the representatives of the people. If that's what the people of Uganda want, let it be. That is what the Constitutional Court re-echoed.
The Constitutional Court really had an opportunity to nullify this law in its entirety, because the law fundamentally violates the rights of a section of people in this country, more especially the rights to dignity, the right to privacy, the rights to equality and non-discrimination, and that's very important. That whereas we may want to criminalize certain things, we may not stop people from existing, which is what this law entirely does. So my take on the law is that it was a missed opportunity by the court of law, by the courts, to declare that this law is completely unconstitutional.
The decision, based on the 16 grounds which were affirmed by the petitioners and the respondents, justices of the Constitutional Court nullified 4 sections from the Act. Out of the 17 sections, the nullified sections include 3 to C, 9, 11 to B, and 14, which highlight issues concerning health, privacy, and adequate standards of living.
And this has challenges for other rights in the country. Today it may be gays, but tomorrow it will come to rights of women. Tomorrow it will come to rights of the Batua. Tomorrow it will come to rights of different people. And then we say, no, what the majority decides is what goes. Because that's why the judgment is exactly saying that the majority define what we should take as legitimate and constitutional, which is a very big problem, because it's not just about the majority, it's also about protection of minorities, and that's a fundamental part of democracy.
Basing their decision on the need to observe the norms, culture and religion, which can't allow activities of gay community in the country, justices had to dismiss the petition.
The Constitution recognizes that we Ugandans, we have our cultures, we have our way of life, and such norms which are believed in by our societies must be upheld by the judiciary.
Cultures are very important and values are very important, but the question obviously is, what are our values as a country? Like, where are our values written? Remember, this is the Constitutional Court, not just any other court. So the Constitutional Court decides on a number of things, and basically the first thing is the Constitution itself. So from the Constitution, what are our values as Ugandans? All right? So if you look at what our values are, we were looking at the rule of law. We're looking at good governance. We are looking at respect for human rights. We are looking at respect for individuals, okay? And also secularism. These are the things that are listed down in our national objectives and principles of state policy. So when you tell me of other values which are not written there in the Constitution, what are these values and where do they come from? For example, as Africans, when do we say this is our culture? When is it our culture? And what does it mean to say? What does it mean? Can we have one culture as Ugandans? Can we have one culture as Africans? What does that actually mean? That's why it's important that you have values that cut across. That is equality and non-discrimination. That is human rights and freedom for everyone. That's secularism. So that since we have multiple religions, everyone can be free to say whatever they want, whether they're religious or not. That's why our values are not what the court purports them to be, but in fact what the Constitution says them to be, and I've stated what the Constitution says are the rights, are the values of Ugandans.
Do you agree with the court's decision when they said that people who are involved, most especially male, who are involved in homosexuality and sort of, they are likely and they are the biggest number who are affected with HIV?
The HIV prevalence rate among men who have sex with men is actually much higher than the average prevalence rate for other people. But the question is, if the HIV prevalence rate is higher, what's the actual solution? Do you criminalize? Now, let me tell you, criminalization is not new in Uganda. We've been criminalizing. For the past 100 years, we've had laws against homosexuality. Has HIV ever stopped because of that? And also, if you look at really, primarily the way of transmission of HIV in this country is primarily heterosexual relations. It's mostly heterosexuals who have HIV in this country, if you compare the numbers in terms of percentages. But in terms of actual numbers, there's out more HIV among heterosexuals than there are among the fewer homosexuals that we have.
Nalukola, however, adds that with the existence of the law against LGBTQ community in the African countries, including Uganda, this shows the stand for the African countries.
Through the Constitutional Court, under the leadership of the Deputy Chief Justice, the people of the Republic of Uganda spoke to the world. They expressed their displeasure to acts of homosexuality. They asserted their will and desires as provided for under Article 126 of the Constitution. You know, judicial power is derived from the people of Uganda, and the judiciary is meant to uphold and protect the desires, the norms, the will of the people, not the will of the foreigners, not the will of European Union, not the will of United States of America. It is time for Uganda to be let alone to manage or mismanage its affairs. African people have their independent and sovereign countries. They have to handle their affairs. They know what they want. They know their norms. If a law was made by the Parliament of the Republic of Uganda, the legislature is composed of the representatives of the people. If that's what the people of Uganda want, let it be. That is what the Constitutional Court re-echoed. But there are challenges which come with independence and sovereignty. Ugandans must tighten their belts. They should stop being beggars and borrowers, because the European Union, United States of America want to advance loans, want to advance aids with conditions. Therefore, the taxpayer should make sure that he or she is ready to pay taxes, and the thieves in government should stop taking money which is collected through taxes and other services. They should stop eating people's money so that that money can be used for service delivery. We should go for total independence if we want our norms to be upheld and protected. The European Union and United States of America will reduce their aids. We must stop borrowing because there are conditions. Therefore, the consequences of that decision against homosexuality are far-reaching if we want to remain beggars in the European world. But the good thing is the decision is against neocolonialism. the decision is upholding the sovereign and independence of Uganda.
However, Dr. Adrian Juko, a law lecturer at Makerere University, has a divergent view over this issue.
Number two, the court also makes it clear that the right to health imposes a number of obligations on people, and therefore, if you impose reporting obligations on doctors, for example, the doctors won't be able to treat homosexuals and give them services. Now, the real problem, although the judgment is affirming on the right to health, the problem with it is that it discusses the right to health only partly. The right to health, in fact, says you should not discriminate. That is the basic, that is the gist of the right to health. So, by the court saying we are going to discriminate against gay people, they're not entitled to equality and discrimination and non-discrimination. At the same time, they are saying these people are entitled to the right to health. This is an oxymoron. It's a contradiction in terms. But if you remain criminalizing, you are promoting stigma and discrimination among the groups. So however much you say, health is okay for health, it's okay for shelter, it's okay for health care, you've not dealt with the main issue of discrimination, which means that these people, if you say, I'm gay and I want to rent your house, they'll be like, no, you can't rent my house. So you are doing nothing by saying, it's okay, they have these rights, but then they are not allowed to exist. So what are you saying?
With the remaining sections in the Act, one may ask whether they are still fit to serve its purpose as aimed by the Parliament.
Yes, the remaining provisions will ably fight the vice. The other provisions which were nullified, it was justified for Constitutional Court to nullify them because they were asserting a duty which is unconstitutional against individuals, for instance, a landlord, to ensure that the tenant who is given, say, premises should not indulge in homosexuality activities that would make a landlord to infringe on tenants' right to privacy, among others. Yet it is the right to privacy is protected under Article 27 of the Constitution. Therefore, I believe the remaining provisions remain prohibitive against homosexuality. Should the legislature find it important to make other legislations, then it can amend the same act, yes, for purposes of protection of the citizens against homosexuality.
So the work of the law is not to prosecute anyone, it's actually to persecute. Now, we've been studying the trends of the law criminalizing homosexuality for the past 100 years. And I can assure you, no single person has ever been convicted for consensual same-sex relations. You see, like someone has gone to court and they have been charged with an offense under the penal code and they have been convicted and there is evidence for that conviction. That has not happened in 100 years. And now, whether you make the law better, whether you call it homosexuality, whether you call it whatever name you want to give it, it won't change the fact that you won't get evidence because these are consenting adults, okay? You will never get evidence to convict them. So then why do we insist on having such a law, yet we never actually implement it? The reason is persecution.
Dr. Adrian Duke is also of the view that the Constitutional Court justices erred in laying their judgment.
Uganda has obligations. Human rights imposes obligations on people. It's not me and what I want. It's not about whether I'm a Christian or whether I'm a Muganda or whatever I am. It's about constitutional values. The idea of constitutional morality, which courts in different countries have discussed. For example, in Kenya, just recently in this year, in Botswana, they nullified the laws criminalizing homosexuality. In India, they talked about same-sex marriages, and they are using the idea of constitutional morality that the morals we talk about are morals in the Constitution, not exactly morals of greet your mother, greet your father. And now, whether you make the law better, whether you call it homosexuality, whether you call it whatever name you want to give it, it won't change the fact that you won't get evidence because these are consenting adults, okay? You'll never get evidence to convict them. So then why do we insist on having such a law, yet we never actually implement it? The reason is persecution. If the law is there, then we can arrest people. We find walking, and we think they are walking like gays. We find talking, you talk like a gay, and they arrest you. And when they take you, they do annual examinations on you, humiliate you, make sure that you can't even go back home because there's nowhere to go. So the whole purpose of the law is to discriminate and persecute, not to prosecute. So this thing of it will work or it won't work is completely useless, meaningless, because the law was not meant to work. It cannot, homosexuality is not something that you wake up tomorrow and say, hey, we have now gotten rid of it. It's not like something you wake up and say, we are now no longer, people are no longer gay, it has stopped and it has ended.
Since the Ugandans moved to enact the Anti-Homosexuality Act, a number of sanctions have been slapped on her and some highly placed government officials.
The challenge is African countries, African, Asian, some South American countries, they are still lagging behind. They have no economic empowerment. And that has given opportunity to the developed world, which hitherto were advocating for independence and sovereignty of countries, to use it as an opportunity to poke their noses in affairs of the developing countries. They think that they can determine what to be done and what not to be done in developing world, which is wrong. And now that we are good borrowers who have failed to manage well our affairs, to utilize our resources for the benefit of our people, now it has become an opportunity for Western world to dictate how to run our affairs. And that is very dangerous. If Africa is to enjoy total independence, it should develop nuclear weapons. It should empower itself economically. But that comes with a huge price of having good governance. We must develop our people as a human resource with skills. We must devise means of utilizing our natural resources to stop that tendency of being beggars and borrowers. Because you have seen those who advance loans to us, they have set conditions. And indeed, some of the activities they want us to indulge in are unthinkable. When you think about homosexuality in African context, sincerely, it is dangerous indeed. So, therefore, they are using it as an opportunity.
Uganda has made a choice. They voted the current government into power based on that choice. Okay, the current government has its own policy, which seems to be passing laws against homosexuals. They are partners. Okay, the West and the World Bank and the others don't want them to pass this kind of laws. Now, their negotiation process, how they discuss their business or how they get money from each other, on which basis, is really a sovereign thing for the country to deal with these partners. Okay, so, and for you people who vote for the government, to also know that, you know what, our government, this is what is getting us in turn. It's giving us, protecting our morals, and we don't have money, and that's okay. We shall eat our poverty and forget about the money. Those are choices a country must make and the people must make. So for me, what's wrong with America saying, I won't give you my money? It's their money, it's not your money. If you want to have their money, then you do what they tell you. If you don't want their money, then do whatever you want. But remember, even if it's not about money, it's also about international obligations that they have the duty to actually also remind you and respect each other in that respect. So for me, it's a choice the government has taken that we are going to pass this law regardless of your money. They should not say that the other people are at fault for putting conditions for their money. It's their money. If you don't want conditions on your money, make your own.
My lords, for the petitioners, we have Mr. Nicholas Ofio.